All rise. We will away. Please be seated.
We are in open session, Your Honors.
Thank you very much. We adjourned in private session. There was a matter that arose then, and the chamber will go back to private session now to make a ruling on that matter.
We're in open session, Your Honor.
Thank you, Your Honours. I won't spend too much more time on this, but the question I'd asked, I may as well get the answer, was whether you had heard this large group of Kalenjins, armed Kalenjins you saw on the 31st, say anything or make any noises.
No.
You did tell the court a moment ago that you had recognized certain people but could not remember their names today, correct?
Yes.
At the time when you made your statement in July 2013, did you remember those names?
Yes.
And did you tell those names to the investigators who took your statement?
Yes.
Very well, I'll come back to that. Now,
Was Phil or feel? Counsel?
thank you, Your Honours. Did you use the word fill, F-I-L-L, or feel, F-E-E-L?
F-I-L-L-E-D.
Perhaps, Mr. President, perhaps it needs to be clarified whether he was told to fill in that information in the diary or it was his own decision to fill that information in the diary. It's not clear in the record.
We're taking it one at a time. We want first of all to know what word he was using, and then I think follow-up questions as well.
Much obliged.
Thank you. Now, I'm taking it from page 98, line 20. You said, I left my diary at home, so they told me. Are you referring to the investigators when you say they told me?
Yes.
They told me that when coming, bring the diary so that we can fill to concur with the statement.
Yes.
So the first question is, where were you when you filled in these entries? Were you at home or were you at the location where you met the investigators?
At the location where I met the investigators.
And when you filled this information in, where were the investigators?
I was with them.
They were present.
Yes.
The information which you filled into the diary, was that correct or incorrect?
Sorry?
Yes, the investigation that you filled in the diary in the presence of the investigators, my question is, was that information correct? Was it true? Or was it false?
Some were true, some were false.
And Did the investigators know that part of the information was false, according to you?
Yes.
And why were you filling in false entries in this diary?
It was to concur with what I had told them before.
In your statement?
Yes.
And what you told the investigators in your statement, was that true or was that false?
Some of the parts are true, some parts are false.
And why did you record false information in your statement to the investigators?
Sometimes back in April last year, that is 2013, I was approached. I don't know if I should mention the name publicly.
You shouldn't mention the name. Approached by, was it a man or a lady?
A lady.
We'll get that information in private session, but for the time being, carry on with your story.
So she told me that she had been approached by investigators from the ICC that they still needed some more witnesses to testify against William Ruto and Joshua Sang. So she told me that it was good for me to join in giving that statement, even if it is false. There is no problem. She told me that if I give out that statement and I am approved to be a witness, I will get many privileges. One, she told me that my children are going to be given free education by the ICC. She told me that I will live a very comfortable life outside Kenya and in country of my choice, and that I can pursue my education while the ICC will be paying for me the school fees. And then finally, which is a personal issue, was because I have been against Ruto from the beginning, naturally. So that hatred that I had on Ruto also provoked me to give false statement.
So were those your reasons for giving a false statement?
Yes.
Were there any other reasons?
Maybe just to add on that is that personally, my earning was very low, so I took it to be fantastic if I can get my children going to good schools, living a comfortable life outside Kenya. Yeah, and then I saw as if it was a privilege to me. And then she told me that this is the only opportunity. If we don't utilize this opportunity, I don't believe any other opportunity will come.
I see. And those are your reasons for giving a false statement, correct?
Exactly.
Just so we can all be sure we're talking about the same statement, I'd like to ask the court officer, please, to call up the front page of this statement for the witness to identify. At this stage, only for identification purposes. Court will bear with me. So, Mr. Court Officer, kindly call up ERN KenOTP 0109 0019, and it's R01.
I take it the material will be displayed in the courtroom only?
I presume so, Your Honor.
That would be the case.
Your Honours, this is at tab 1 of Your Honours' binders. And if I may ask the court officer to inform us when the witness has that before him.
The witness is being showed the document as referred to by counsel, first page, ending in 0019, redacted version.
Thank you, Mr. Court Officer. Mr. Witness, and we are in public session, but is that your name that appears at the bottom of the page?
Yes.
And is that your signature and the date of your signature to the right of your name?
Yes.
And below your name, there are two further names. Who are those two people? Without mentioning their names, what was their part in this statement?
They were investigators.
They're the investigators that interviewed you and took this statement.
Yes.
And above your names, it's reflected the statement was taken over 3 days, from the 6th to the 8th of July 2013. Is that correct?
Correct.
Very well. Mr. Court Officer, can I please ask you to then just display the last page of the statement? The final 4 digits of the ERN are 0050.
It is being displayed.
And Mr. Witness, can you again confirm that that is your signature and the date of the signature on the last page below the witness acknowledgement?
Yes.
All right. And so we're all clear, this is the statement that you say you gave false information to the investigators in. Correct?
Yes.
Since you gave this statement in July 2013, have you ever told, well, is it correct that you've been in communication with other members of the prosecution besides these two investigators that took the statement?
Yes.
And have you ever told any of those people that the contents of the statement are, in part at least, false?
I haven't.
Is it also correct that between the time you gave this statement and present, you have had certain dealings with members of the Victims and Witnesses Unit of the ICC?
Yes.
Is this on more than one occasion?
Yes.
Are you aware, sir, that the Victims and Witnesses Unit is not part of the prosecution? They are responsible for the protection of witnesses. Are you aware of that?
Yes, I am aware.
Did you ever tell any person from the VWU that the statement you'd given to the prosecution was false in parts?
I haven't.
Sir, the prosecution was recently sent a copy of an affidavit which purports to have been attested by you on the 11th of August 2014. Did you attest to such an affidavit on that day?
Yes.
And on the face of that statement, it appears to have been made before a lawyer from Kipsang and Mutai Advocates. Correct?
Correct.
And in fact, it appears to... Sorry, I'll start that one again. Now, this statement was made less than 3 weeks ago. I presume you're familiar still with the contents. Is that correct?
Pardon?
What do you mean, statement? Do you mean statement or affidavit?
I beg your pardon.
Not that they may not mean the same
Yes.
thing, but since you've been using certain terminology, it might be to be precise and true.
Yes, Your Honours, I will try to refer to this as the affidavit, since it has been sworn under oath, and the statements made to the prosecution as statements. This affidavit was made less than 3 weeks ago, Monday, just over 2.5 weeks ago. Is that right?
Yeah, right.
Do you still recall now, less than 3 weeks later, what you said in the statement?
In the affidavit.
Sorry, in the affidavit. Do you understand?
Yes.
And what's your answer? Do you remember?
Yes, I remember.
All right. And just for identification purposes, I again just like to call up this document. And the ERN is KenOTP 01351135, but the first page of the document is in fact 1137, and it's not redacted. Mr. Court Officer, could I please ask you to call that up?
Is it in your bundle?
Yes, Your Honours, it's the last document in my bundle, tab 68. And, Mr. Witness, for the time being, all I'd like you to do is look at the name and confirm that is your name on that page. Please confirm.
Yes, it is.
Thank you, Mr. Court Officer. Please then call up the last page of the affidavit, which I believe is 1139.
I have with me page 1140, which corresponds to the last page of that document.
Thank you.
113.
1140 that it is then.
The affidavit?
Of the affidavit. The court will bear with me, please. Unfortunately, the version I have does not have an ERN on it.
What we have as 1140 is a handwritten letter.
Yes. No, in fact, the page I'm looking for is 1139. That's a separate document.
Page 1139 is being shown.
Thank you. Do you see your signature there too, sir?
Yes.
There is a stamp that appears to be a stamp of S. Kibera Minor, Advocate, Commissioner of Oaths and Notary Public. Is it correct that you were administered the oath
Yes.
and you swore that the statement was the truth?
Yes.
Who actually drafted the statement, physically did the typing of it? Drew up the statement on your instructions?
Pardon?
Who drew up this statement?
Yeah, I instructed my lawyer.
Which lawyer was that?
He's called Gregory Mutai.
All right. And that is, in fact, counsel who's representing you today, correct?
Yes.
Then one last document to identify. If you could now call up 1140, 11 ERN 1140, which is the last page of the bundle. That appears to be a handwritten statement also by yourself, and you confirm your signature and ID number at the bottom.
Yes.
All right. Thank you. Those can be taken down, Mr. Court Officer. Now, you recall what you said in the statement you said, and in fact, you confirm under oath in this statement that certain of the details you gave prosecution investigators in July 2013 was false. Is that right?
Yes.
Again, Steinberg was referring to the affidavit.
Yes. Yes, my apologies. All right, let me just move away from that for a second. Since your appearance before this court on Monday this week, have you had occasion to speak to members of the VW, Victims and Witnesses Unit?
Yes, we are talking with them. I'm talking with them.
And did members of this unit convey to you a request by the prosecution to hold a witness consultation, witness preparation consultation prior to your evidence? Did that happen?
Pardon?
Do you understand the question?
No, I want them to repeat, Your Honor.
I'll try to rephrase. Did members of the VW convey to you that the prosecution wanted to meet with you to conduct witness preparation?
Yeah, they told me on Monday.
And what was your response to that request?
I told them I am okay.
What does that mean? Did you or did you not want to meet with the prosecution?
I didn't want to meet with the prosecution.
And why is that?
Because I had written a letter withdrawing my statement.
All right, thank you. The court will bear with me 1 moment. Yes. Your Honours, I believe we've reached a stage where the prosecution is constrained to make an application. The first order of business is to consider whether it's appropriate to make that application in the presence of the witness. In my submission, certain matters which are likely to be debated may foreshadow questions which might follow later on, and for that reason I would ask that the witness be excused for the purposes of any debate that there may be about this application. Of course, I have no objection to counsel remaining, counsel Mr. Mutai.
Defense, do you have any difficulty with that request from the prosecution?
No objection, Mr. President.
Mr. King Katwa?
I do not have an objection, though the nature of the application to be made has not been stated. We can only conjecture what it is.
All right. The chamber grants the request for the witness to be excused for a moment while the lawyers debated a certain technical legal matter. Witness 604, the registry representative would take you out of the room for now. Just wait for us and we will call you back in.
Okay, thank you, Your Honor.
Thank you.
Mr. President, the witness has been escorted out of the transmission room.
Thank you. Please proceed.
Thank you, Your Honours. Your Honours, this witness was called by the prosecution on the basis of...
We are in open session.
All right. Right, sorry, there was some interference in my headphones. The witness was called by the prosecution, Your Honours, on the basis of information and evidence he provided to the prosecution previously in certain statements in July 2013. It is now apparent, Your Honours, that he no longer stands by that evidence, and he has indeed recanted that evidence. He has since attested to an affidavit this year under oath in which he recants material portions of his evidence, and in particular portions of the evidence which are relevant to the roles ascribed by the prosecution to the two accused before court. So there is little doubt in my submission that the witness's evidence is certainly now adverse to the prosecution's case. Further to this, Your Honour, the witness has, in his statement, ascribed actions to prosecution investigators which, if true, would amount to crimes, serious crimes. Your Honours, I'm seeing a disconnect message.
Mr. Mutai, can you hear us?
Mr. President, I can hear you.
Thank you.
I'm grateful, Your Honours. Yes, so he's not only recanted his earlier version, but he's made allegations of improper and indeed illegal conduct on behalf of members of the OTP. Finally, Your Honour, he has refused to meet with the prosecution and broken off all contact with the prosecution. Your Honours, the prosecution has not, in the circumstances, gone through the intermediate step of refreshing the witness's memory from the original statement, since he has already clearly stated under oath that that statement was false. I submit that that would be an exercise in futility. Your Honours, the declaration of witnesses as hostile for the purposes of permitting the calling party to cross-examine is not a novel matter, neither in this court nor in domestic jurisdictions.
There are some tests that should be applied.
Yes,
they're not. Okay.
There are, Your Honours, and I will
Let's hear those.
Address those at the moment. The Chamber will bear with me. I refer in the first instance to a judgment in the case of the prosecutor versus Thomas Lubanga Diallo, and it's ICC 0104 0106 2201 redacted, dated 2nd of February 2010, where at paragraph 19, His Honour Mr. Justice Fulford remarked as follows: the reality of the current position, I beg your pardon, let me start a little bit further down.
Do we have that material?
No, Your Honours, I'm afraid we haven't put court records in the bundles.
Well, the practice normally isn't it the case that people should hand up material that legal authorities to judges so we can see them, unless you want us to adjourn and go and review the material from our own research.
Your Honours, my understanding was that the practice would be to hand up material that was not part of the ICC jurisdiction if it was from some other. But I understand the practical difficulties.
It is a practical difficulty. Even in this case alone, we have made, if you started counting, I do not remember how many rulings we have made. It would be too much to expect that every ruling we have made, that we should have videographic memory of it at every time, let alone case law of other chambers. So yes, we can look at them if there had been submissions made earlier in writing, but if you are speaking to the matter on your feet, it's best to hand up those materials so we can be looking at them.
I'm afraid I don't have copies immediately to hand, but within a few minutes I could get copies like that if the Chamber is minded to
See,
But let me read verbatim what it says, and it will then be on the record. From halfway down, paragraph 19, the learned judge says, additionally, given the wholesale change of account, it would be unfair to the prosecution and it would potentially impede the Chamber in its pursuit of the truth if the prosecutor is at this stage restricted by the limits that are traditionally imposed on, quote, examination in chief, unquote. And then at the end of the paragraph, in these particular circumstances, it is undoubtedly appropriate for the prosecution to ask closed, leading, or challenging questions as necessary. If the prosecutor is restricted to neutral questions, he will be unable to explore adequately the circumstances of the change of account and the reasons for it. Your Honours, as in the case quoted, the witness at hand is undoubtedly given wholesale change of account.
let us understand what the authority you have read says. The reason I say it, you began your submission Yes. You began your submissions by announcing that declaring a witness hostile is nothing new. You said the same thing as requesting to ask a witness leading questions.
Your Honours, practice differs in various jurisdictions on this point. In certain jurisdictions, it's sufficient that the witness has given a version which deviates from the version given to the party calling it. In other jurisdictions, certain additional indicia are required. In my respectful submission, in the case at hand, in the Lubanga case, in the Lubanga case, no such additional indicia were required. And my submission is that this is also consistent with the practice at the ad hoc tribunals, in particular the ICTY. And further on in this judgment, at paragraph 20, the Chamber quotes from various, or refers to various judgments in the ICTY, the judgment of the prosecutor versus Halilovic, and this is at footnote 34. Where
right, so, I'm not sure that you understood what I was saying. Maybe I wasn't clear enough. What I was saying is the authority you read out says it is undoubtedly, quote, it is undoubtedly appropriate for the prosecution to ask closed, leading, or challenging questions as necessary. If the prosecutor is restricted to neutral questions, he will be unable to explore adequately the circumstances of the change of account and the reasons for it. Unquote. Isn't that the point of the ruling?
Indeed, Your Honours, but the purpose in my submission for a declaration of hostility of the witness is in order to permit the calling party to cross-examine that witness through the normal techniques of cross-examination, including challenging questions, closed questions, and leading questions. And that is where I'm heading with this.
I'm not sure it's the same thing. You don't have to declare a witness hostile to ask them leading questions, do you? Yes, of course, if you declare a witness hostile, you can do all of that. But it is possible to just zero in on your need for leading questions without incurring the tests for leading questions as such. I don't know if you get my point.
I understand the distinction, Your Honours. However, in present circumstances, perhaps the argument is moot, because in my submission, this witness is undoubtedly a witness who would qualify as a hostile witness.
And that's another matter, so you can argue that. And I thought you were going to bring out in the Lubanga decision the circumstances in which the witness was declared hostile, if the witness at large was declared hostile.
Your Honour, the request was not framed in those terms. In fact, the request was titled "The Request on the Manner of Questioning of Witness 15" in that case.
So it was not a declaration of hostility at large?
No.
Yes, that's what I thought.
Yes. Returning, though, to my reference in footnote 34 to what is meant by a hostile witness and the jurisprudence of the ICTY in that regard, it refers to, the learned judge refers to the decision in Halilovic, which states that a hostile witness is one who, quote, testifies in contradiction with his previous statements, unquote. In Prosecutor versus Radoslav Burdanin, it was said that a hostile witness is one who is called by a party under the assumption that the witness will give testimony favorable to that party, but in fact the witness, quote, becomes a hostile witness, saying exactly the opposite, or refusing to answer questions which the calling party knows he or she has got a very straightforward answer.
A number of concepts were rolled into that very last thing you read in. Giving unfavorable testimony need not be an indication of hostility, is it? Or need the witness have done something else, refusing to answer questions?
Yes. Your Honours, I would submit that he doesn't need to. It's not simply a question of giving evidence which the calling party did not expect. That may be explained by a number of reasons, lapses in memory.
Not what the calling party did not expect as such, but unfavorable testimony doesn't make a witness a hostile witness.
Well, it would seem that according to the jurisprudence of
yes, according to the
first
did
one.
you say Ililich?
Halilovic.
Halilovic?
I understand.
That is what it says, yes.
Yes.
But are we bound by that?
Of course not, Your Honours, no.
Thank you.
The submission of the prosecution, however, is that the weight of authority in the ad hoc tribunals is that it is sufficient for a witness to contradict his earlier version to be declared hostile. But in the present case, perhaps it's not necessary to debate too fine a point on that, the witness has gone further. And apart from disavowing material portions of his original statement, he's made allegations against the conduct of the members of the prosecution, as well as his refusal to have any contact with the lawyers of the prosecution, which, in my respectful submission, show very well that he is adverse or hostile towards the prosecution as such.
Right now, if a witness, taking those two grounds you posited, and of course I'll be hearing from the defense later. Let's take the matter of refusing to meet with the prosecution. If a party in a case invited a witness, the witness is in your interest that I meet with you and prepare you. Say, no, I don't need it, say the witness. I'll meet you in court. Let's assume that that is the case. I do not want to meet you before court. I will come to court and testify, but I don't want to meet you. Does it make that a hostile witness?
On its own, perhaps not, Your Honours, but it's obviously the combination of factors. And, I mean, I could perhaps have started with the fact that the witness had to be brought to court under compulsion after refusing to cooperate and come to court voluntarily, notwithstanding his earlier indication that he would. So that, together with his recantation, together with his accusations against members of the prosecution, together with his refusal to have any contact with the lawyers from the prosecution, Your Honours, I submit, combined, provides a compelling example, and I can scarcely imagine, short of a witness abusing the prosecutor on the stand, I can scarcely imagine a much more compelling case for the declaration of a witness as hostile.
Is it a small matter? You threw in that last bit as if it was something casual, but is it that casual? Is there a difference or not between a witness who might have said something to give the prosecutor reason to suspect that this might be a hostile witness by writing something that is not part of the record to begin with, directed to the prosecution or the party intending to call the witness before the witness actually comes to the courtroom? Does that sort of material necessarily follow the witness to the witness stand, or is more required to establish that, yes, the abusive communication that a witness made before coming to the court, that he has indeed continued to make such abusive allegation against the party?
Your Honour, if it was sufficient just that, if one can call it an abusive communication, if I refer to the affidavit where serious allegations are made, if it was sufficient that that was enough to declare hostile, then I could have made the application before the witness even got into the witness stand. But in the prosecution's view, the witness should always be given the benefit of the doubt to start with. But now that the prosecution has, before the court, under oath, confirmed the contents of that affidavit, including those allegations, and indeed repeated allegations that members of the prosecution had told him to fill in false statements in his diary, to reconstruct his diary, to coincide with his statement, in my respectful submission, is sufficient to show that he is hostile to the prosecution. There are certain jurisdictions where the demeanour of the witness in the witness box is a factor which is taken into account and to which some importance is given in deciding on a request to declare him hostile. But in my submission, the weight of the jurisprudence in this court and before the independent tribunals is that that additional factor is not a prerequisite, where in these circumstances at least the witness has recanted, made allegations against the party calling it, and refused to cooperate with the party calling it. Your Honours, the purpose of all of this is obviously to request that the prosecution be permitted to cross-examine the witness on his latest version and on what is recorded in his first version, and to explore where the truth lies. The prosecution will, during the course of this exercise, request that the statements referred to be admitted for the purpose of impeachment at this stage, not for the purpose of the truth of the contents. However, the prosecution has made it very clear that in due course, and if it can establish that the reason for the witness's recantation was due to or materially affected by improper interference, we will be requesting that the statement be admitted under Rule 68 for the truth of its contents. And I make that point pertinently because it may instruct my learned friends as to questions they might wish to put to this witness in cross-examination, bearing in mind that the prosecution does intend to rely in due course on the content of the original statements.
Thank you very much. Mr. Khan?
I'm grateful, Mr. President, Your Honours. In our respectful submission, the application by my learned friend is not only poorly founded in law on the present facts, but in any event, taken at its highest, is premature. Your Honour, if one goes back to basics, because the issue of hostility, and for that was his application, is effectively a concept that derives originally from the common law, for understandable reasons. And the rule is that generally a party, a calling party, is not allowed to impeach one's own witnesses. And in circumstances where a calling party effectively is taken by surprise with an account which they did not expect, the common law had sufficient flexibility that it allowed that calling party not to be ambushed or taken by surprise, but to test by leading questions after a declaration of hostility the witness's account, effectively to neutralise often exonerating evidence. I pause there for a moment. In assessing the merits or otherwise of the application, it is important in our respectful submission to note that the witness thus far has not exonerated Mr. Ruto. It's very important. He may not have given evidence that the prosecution want. Of course, he wasn't proofed. But he's given, we say, so far, it appears, a truthful account, and that's important. For what is the standard? We say, Your Honour, before, and if my learned friend, and Your Honour is quite right, it is permissible to ask leading questions, even absent a declaration of hostility, in circumstances, for example, where the defence by consent says something is not an issue. By consent, of course, to save court time, leading questions may be asked, but not where the purpose is to discredit one's own witness. Where the purpose is to discredit one's own witness, the rule of hostility is important because it goes to the truth-seeking exercise that the prosecution has repeatedly said it's interested in. And in determining the merits or otherwise of the application, Your Honours, it is important that unlike the Lubanga case that's cited, the prosecution was forewarned on the 11th of August 2014 at the latest that the witness had repudiated a previous account. And notwithstanding that repudiation, the prosecution maintained that it wished to call this witness, call him to knock him down, to discredit. And Your Honours, we say that poses an ethical issue, because with the assistance of this chamber, the prosecution, after 10 long, painful years, finally enacted a code for professional conduct for prosecutors. And Your Honour, paragraph 63A of that, chapter 4, section 2 of the Code of Professional Conduct. Prosecutors are enjoined, and they publicly have stated, that they must not present evidence knowing it to be false or forged. And that admonition is repeated later on in paragraph 71, that the prosecution must not present evidence knowing it to be false or fabricated. And yet here we have the prosecution, despite an affidavit, bringing a witness and now seeking to discredit that witness, we say.
Have they presented evidence, or are they seeking to present evidence knowing it to be false?
Well, Your Honours, they've called a witness knowing that the witness has given an account which repudiates a previous narrative. and which the witness has stated under oath, and knowing that, the prosecution take the risk, we say, that that's the substance of the testimony. Now, Your Honour, importantly, unlike prosecution witness 16, where the prosecution have said we're investigating, they haven't critically sought to investigate the veracity or otherwise of the account. They've jumped, and we say it's lazy prosecution, I'm sorry to say. They've jumped and said we intend to confront him with a previous statement, and we may later confront him with other evidence showing foul play. Your Honour, as a matter of principle, we say, given the importance of Article 54, it doesn't go into hibernation at the commencement of a trial. It remains wide awake, or it should if it's properly applied, even now. And the prosecution have a duty to get to the truth, even when a witness is in the box.
Mr. Ken, can you limit yourself to the application to declare the witness hostile? It looks like you are bringing in a lot of things, including what might, if you boiled it down, be possibly revisiting the question of whether the subpoena decision was properly grounded or should have been made. Let's just limit the submissions to whether or not this witness should be declared hostile, and what do the law, as you know it, said.
Well, Your Honour, I'm grateful. I'll be so guided. I've said at the outset the origins of the rule, which is important to its application. Your Honour, in the Katanga case, it's a decision of the trial chamber in the hearing, Tuesday the 9th of February 2010, at page 20, and I have a copy here for Your Honours if you wish. The chamber stated something which is well known, we say. The chamber, and I quote, at lines 11 to 14 of page 20, the chamber would like to stress that the simple fact of sometimes having unfavourable answers is not in itself enough to mean that a witness is declared hostile. Your Honours, in assessing hostility, we say the prosecution need to establish one of two things. Either that the witness displays a hostile animus to the prosecution in the sense of being undesirous of speaking the truth.
But the prosecution is saying, in terms of hostile animus, that the witness had made unsavory allegations against the prosecution. Does that not count? Or rather, allegations of illegal and improper conduct, to put it precisely, against the prosecution, that was done in an affidavit, and while on the witness stand, the witness admitted that he indeed did swear the allegation, an affidavit saying those things.
Well, Your Honours, on that issue, then we go back to what's the purpose of all of this, because a declaration of hostility is not meant to simply neutralise a witness. Sorry, it is a process to neutralise a witness that's exculpated an accused. Your Honour, if there's an ancillary issue that the prosecution have got certain allegation, there's two matters. The first is, I note, the prosecution didn't really ask what I would say of detailed questions on that issue. They touched and went, so to speak. They touched and they didn't probe in a necessary manner. But secondly, that's a complete red herring. That's a complete red herring. And we say what's important is Your Honour's own assessment, not the prosecution, not the fact that he may be an unfavourable witness to the prosecution, because we haven't even seen that. It's Your Honour's assessment at this moment, is that gentleman who has voluntarily come, albeit with a summons, to give evidence, and for the first time since this hearing started, this trial started, we respectfully submit he was told in underlined terms, in highlighted terms, about the importance of Article 70 and the liability for prosecution for giving false evidence. Is it right to allow the prosecution to declare that witness hostile when so little information has been obtained? Your Honour, it's now respectful submission.
The point you're making is that you started with saying, so far the witness has not exonerated Mr. Ruto, your client. So your point, isn't it, this, that if there are some discrete items of information, evidence as it were, that go to any such question, the prosecution has not asked those and indicated difficulty getting to those by way of first we try leading questions to see if that could help. Then if during leading questions it becomes clear that nothing works, then we may come to the second option, hostility.
Exactly right. That's it in a nutshell. And that goes to my point that in any event it's premature. The prosecution, leaving aside the fact that they're not even attempting to put a statement to the witness as a memory refreshing document, they haven't even attempted to take the trouble to enlighten your honours and all of us as to which parts of the statement are true and which parts are false. And the witness has said some parts are true, some parts are false. And these are not procedural niceties. These are necessary steps, we say, in getting the truth out. The prosecution premature application, we say, to declare the witness hostile is a recipe to stop a full narrative being given. It should be rejected on legal grounds because there's no evidence of a hostile animus or that the witness is undesirous of telling the truth. He's attempting to tell the truth, but in any event, the prosecution haven't diligently asked probing enough questions to separate which parts are truthful in the statement and which parts are not. Those are necessary steps, we say, before jumping the gun, as we say, my learned friend for the prosecution has done in seeking to declare the witness hostile.
Mr. Kikin-Kaswa, do you have anything to add to that, and how long will it take you?
With your permission, Your Honours, I am requesting Dr. Buisman to respond to that point.
Ms. Basman, how much time would you need? You see, it's time for us to adjourn for the day.
I would need probably 5 minutes.
All right, Ms. Bausman, we will take your submissions tomorrow morning at 9 o'clock, 5 minutes, and if you have any response, Mr. Steinberg will do it at that time as well. Any reply, rather.
Thank you.
We'll do it at that time. We will now adjourn, and we start again, we reconvene tomorrow at 9 a.m., not 9:30. Okay.
All rise.